A very good evening, everyone. Before we begin, let's have a quick audio-visual check. Am I audible? Am I visible to everyone? Yes. Please type a yes in the chat box if that is correct. Am I audible? Am I visible? Yes. Okay. Good evening, Anushri. Good to see you here. Good evening, Kishan. Good to see you guys. Hi, Tanvi. Okay. Thanks for letting me know कि भाई audible भी हैं और visible भी हैं. Okay, great. Then I think we can begin. Acha, today's session is in continuation of the session we had last time. There were certain important doctrines of constitutional law which we are discussing in these sessions. Last time we had picked up around 4-5 of them. Today we are going to continue with them a little further ahead. Right now, the doctrines which we are doing this time are all generally relating to state-center relations, right? So the various ways in which the conflict between state laws and central laws, all that is what we are going to look into primarily in today's session. Okay, so let's all get started. Now, those of you who are new to our channel, maybe who you are hearing me for the first time, then let me just give you a brief intro. We help students for CLAT preparation, and I have these Thursday to Thursday legal sessions for the legal reasoning section. Basically, today's session is continuation of the last session we had on constitutional law doctrines. Today also we are going to continue with them, right? So that being that, let's start. चलो, अब ये वाली कुछ doctrines हैं जो हमने discuss करनी है अपने sessions में. Now, some of them we discussed last time, like eclipse, severability, judicial review, reasonable classification, basic structure, harmonious construction. All these we had discussed last time. Today, what we are discussing are all of these, right? Whatever is left here, all of these we'll try to cover in today's session. Now, majorly what you'll realize is most of them, you know, whether you talk of colorable legislation, pith and substance, ancillary, territorial, repugnancy, most of them, especially these 1, 2, 3, 4, 5, 5 of them are basically all a product of our federal system. You know, everybody knows that we have a federal system with a unitary bias, right? So bias हमारा unitary union की तरफ है, but system हमारा federal है. तो जहां overlap होता है, जहां inconsistency होती है, so what will prevail? कि कौन सा किसका law prevail करेगा? Whether the state will have an upper hand or the central will have an upper hand. Now, this is a question which comes up before the courts very often. So when they have to, you know, give a decision कि भाई center का law prevail करेगा या state का prevail करेगा, there are various basic principles of law जो कि courts look in करता है, right? They take the help of these doctrines to give their decision. So today we are going to discuss in detail कि भाई कौन से doctrine का कैसे interpretation है जिससे कि courts finally, जिनके basis पे court finally decision देता है. Because if you remember correctly, doctrines, the word doctrines is basically another name for principles. ठीक है, तो जो कुछ basic principles of law जो होते हैं, जो important हो जाते हैं, जो precedent के तौर पे use होने लगते हैं, you know, which have been given authenticity, which have been given an official status because of the fact that Supreme Court or High Court or some other court, basically the Supreme Court or the High Court have used them and have set precedents. Okay, उनके जो judgments में they have become a part of the obiter dicta or ratio. क्या होगा? Ratio है वो या obiter है जिसकी वजह से it is binding? Can you tell me? रेशो होने की वजह से बाइंडिंग होता है या ओबिटर होने की वजह से बाइंडिंग होता है? क्विकली टेल मी. रेशो की वजह से बाइंडिंग होगा या ओबिटर की वजह से बाइंडिंग होगा? ओबिटर of a matter is the one which is binding, or is the ratio which is binding? Quick, I'm waiting. Yes, this is one thing one tends to generally get confused quickly. Tanvi is saying it is obiter. What about the rest of you? What is it? Obiter or ratio? It is going to be ratio. It is not obiter, it is ratio. Always remember, obiter जो होता है वो not binding होता है. Obiter होता है जो कि normally court चलते फिरते या फिर obviously court चलते फिरते नहीं बोलता, which the court is making as an observation, right? It is not giving a decision on something which is the question or the fact in issue or the matter which is in issue which the court has to decide, right? तो जो main matter है जिसके ऊपर court ने decision देना है, something which is not forming a part of it is known as the obiter, and ratio is that part which is going to be binding, right? Something which is binding, something which is actually what court is deciding कि भाई ये वाला एक क्वेश्चन है, मान लो कोई चार्ज था क्रिमिनल लॉ में, तो जो चार्ज के ऊपर जो डिसीजन दे रहा है दैट इज गोइंग टू बी रेशियो एंड इट बिकम्स बाइंडिंग, राइट? सो एनी which ways, little things which one should be aware of. Okay, so now we are going to continue with our doctrines. ठीक है, तो अब हम देखते हैं कि हमने सबसे पहले आज कौन सा डॉक्ट्रिन करना है. So the first doctrine which we will do today is your doctrine of territorial nexus. Okay, so when you look at the doctrine of territorial nexus, what it basically talks about is usually whenever we are looking at a state and center, you have your article 245 of the Constitution, which provides that both the parliament and the legislature shall make laws, and those laws are going to be applicable on the territories of that state, right? So far as parliament is concerned, it's going to be the territory of India. So far as the state legislature is concerned, then it is going to be whole or any part of the state, right? So they have the power to do this only so far as the specific area or the state is concerned. So normally, which means that if it is the state of Madhya Pradesh, then whatever the state government makes the laws, those laws are going to apply only within the state of Madhya Pradesh. They're not going to apply across the country, right? But when you look at the concept of territorial nexus, what it tries to say is it is talking about a scenario where even though the law which is made for the state by the state of MP, but you are trying to apply it on somebody who is outside your territory. So when can you do this? This is like extraterritorial application of your law. So when is this extraterritorial application of the law allowed? If there is a nexus between the law. Nexus means there has to be some sort of a relationship. So if you look at the concept, now territorial means the region or the location. And when you look at the word nexus, it means it is related to persons, objects and all. So when you are talking about it being related to persons, objects, here what is happening is that if there is a relation between, even though, let's say, the MP government made a law regarding, like this is an actual case which had happened, right? So there was this particular person who had a printing business. They had this newspaper printing business, and this particular newspaper printing business was based in Madhya Pradesh. Okay, so let's say their head office and everything was in Madhya Pradesh. This is where they even had their factory. This is where the newspapers were being printed. From here to the adjoining state, Chhattisgarh, these newspapers were being sent. Now, majority of the sales of this newspaper was happening in the state of Chhattisgarh. That means the sales were happening in Chhattisgarh. The money was being earned in Chhattisgarh. So here, the state of Chhattisgarh decided to put levy a tax on this particular company, which actually had its head office in the state of Madhya Pradesh. So obviously the question arose, can you really put a tax on somebody who's not in your territory? Because here, his office, his factory, everything is in Madhya Pradesh. Only the sales is happening in Chhattisgarh. So came the question of territorial nexus. So obviously it is outside. This person is located outside. But here, can you say that there is a nexus between the state of Chhattisgarh and this entire activity? And the answer would be a yes. Because end of the day, all that money, the sales which is happening is within the state of Chhattisgarh. You know, the people of Chhattisgarh are paying for that newspaper. So since the majority of the sales were happening within the territorial area of that particular state, the court allowed that fine, you can actually put a tax, you can levy a tax on that entity, even though that entity is somewhere outside. So when you are looking at the concept of territorial nexus, this is something which you keep in mind. You have to see whether you can establish a relationship between those two or not. Now, another important aspect when you look at the doctrine of territorial nexus is when you're looking at, within the country as a different states, when it is a conflict between different states. Another reason or another way how doctrine of territorial nexus is interpreted is when you're looking at the laws made by the parliament. Now, parliament as such can make laws over the entire country. So what if parliament is making laws on somebody or, is going to govern something which is outside the territory of India? Then what will happen? Can that be held valid? Can that not be held valid? Again, you take the help of doctrine of eclipse. And there, when you're taking the help of doctrine of eclipse, how do you interpret it? Very specifically, Article 245 says that no law made by Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation, which means the Parliament does have the right to make laws on something which is beyond the territory of India also. Right? So, उसमें कोई parliament constitution नहीं allow करा हुआ है parliament को. But when will such a law be valid? Such a law is going to be valid only and only if there is some sort of a nexus which exists. Right? So there has to be some sort of a relationship between this law which has been made by the parliament and what is it that it is trying to cover. Agar ye nexus exist karta hai, then it is going to be considered as valid, otherwise not, right? So this is something which is very, very important. ठीक है, ये चीज जो है ये आपके साथ हमेशा ये मतलब this is something which you remember. Otherwise, normally what happens is when you see questions on territorial nexus, you generally think they're limited to disputes between, maybe just two states. But यहाँ पे एक और interpretation हो सकता है territorial nexus का when you're talking about laws governing things which are outside. Of course, some of you must be thinking कि मैम ये नेशनल लॉ का कॉन्सेप्ट आ जाएगा इसमें हमारी इंडियन लॉज कैसे वैलिड हो सकती हैं. देखो, दैट इज समथिंग एल्स. नाउ व्हाटएवर लॉज वी आर मेकिंग इन आवर कंट्री, वी आर जस्ट looking at the fact that is this law valid as per our constitution. And territorial nexus बोलता है that अगर कोई relationship बनता है आपका कि इंडियन लॉ एक्स्ट्रा टेरिटोरियल उसकी हम एप्लीकेशन कर रहे हैं along with the subject, then it's fine. Then it might have it might have validity, right? But अगर कोई nexus नहीं है, कोई relationship नहीं है, then it will obviously not have that kind of a validity, right? So that is something which you keep in mind when you look at the question on doctrine of territorial nexus. Okay, I hope this is clear to everybody. Yes, if it's clear, we move on forward from here. I would wait for a minute if there is anybody who has any questions to ask. Otherwise, we are moving on, right? Now, the next doctrine, like I was saying, ये सारा ज़्यादा हमारा center state वाला है. The next thing which is important here is the next doctrine which we are looking at is your doctrine of pith and substance. Now, if you're looking at the doctrine of pith and substance come to play when you are looking at the 7th schedule. So 7th schedule हमारा किस चीज के बारे में है? It basically talks about the 3 lists. Right, so when you look at the 7th schedule gives you the 3 lists. You have the central list, the state list, and the concurrent list, right? So generally, the Constitution has tried to create what is also known, this is actually an example of the concept of separation of powers, right? So separation of power का जो concept है, वो ये सारे जो हम आज इनफैक्ट डॉक्ट्रिन्स कर रहे हैं, चाहे आप टेरिटोरियल नेक्सस उठाओ, चाहे आप पिथ एंड सब्सटेंस उठाओ, इंसिडेंट एंसिलरी उठाओ, these are all examples of doctrine of separation of power. Separation of power is that, you know, there has to be separation of power not only in context of the 3 organs of the government, because normally जब हम separation of power सोचते हैं तो हमारे दिमाग में आता है कि 3 organs of the government के बीच में separation of power होना चाहिए. You know, your legislature, executive, and judiciary. That is one way to look at it. Another way to look at separation of power is when you're looking at the separation between the center as well as the state. So ये वाला जो separation of power है, ये constitution में कहाँ दिया है? When you look at the 7th schedule. Very specifically, categories have been created कि भाई इस पे state law बनाएगा, इस पे center law बनाएगा और इस पे concurrent होगा. Now on the face of it, of course, it looks very clear कि भाई पूरी list बना के दी हुई है आपने कि किस पे कौन law बनाएगा. But there are a lot of times when there is overlapping which happens. Now when you are looking at a case where overlapping is happening, like there is a claim made by one of the parties, it could be the center or the state, कि भाई तुम encroach कर रहे हो, you are encroaching on my field, there is an encroachment on my field. So that is what the doctrine of pith and substance tries to prevent, right? Encroachment or intrusion between the two is what you are trying to prevent. Now, when you look at the doctrine of pith and substance, what it basically refers to is कि आप क्या check करोगे? True nature और character of law. कि भाई आपका जो law आपने बनाया है, जब आप ओवरलैपिंग चेक कर रहे हो कि भाई क्या आप बियॉन्ड जा रहे हो अपनी पावर से, सो व्हाट यू वांट टू चेक इज व्हाट इज द ट्रू नेचर और कैरेक्टर की आपका लॉ का बेसिक ऑब्जेक्टिव क्या था. आपका ऑब्जेक्टिव वाज इट समथिंग व्हिच इज कमिंग विद इन द पावर गिवन टू यू बाय द कॉन्स्टिट्यूशन. If it is something which is given to you by the constitution, अगर उसी के अंदर आ रहे हो, then fine. But if you're going beyond that, then you are going to, you know, that particular law is going to be considered as invalid, right? So important cheese is you have to check that what is the pith and substance. What is it that you are trying to achieve under that law? What you are trying to achieve under that law is provided within your list, then it is valid, otherwise not. इसमें एक बड़ा famous case था on these loudspeakers, you know, so there was these amplifiers which were being put everywhere and government ने, state government ने एक law बनाया कि भाई ये जो amplifiers हैं इनके regulation के लिए कि भाई इससे ज़्यादा sound नहीं हो सकती, इतने at night you can't make such sounds, in certain areas आपका restriction लगा दिया, you cannot put amplifiers in schools, hospitals and things like that. So there was this particular law which regulated the use of amplifiers. Okay, so that was the law. ये law बनाया state government ने. अब इसको चैलेंज कर दिया सेंटर ने. सेंटर ने बोला that this particular law here which is regarding amplifiers is encroaching upon the state subject, because ये state का center का subject है, that any kind of law on telegraph, communications, you know, telephones, any of these kind of things, ये domain है center का. तो तुमने एम्पलीफायर के ऊपर रेगुलेट करने के लिए लॉ बनाया, एम्पलीफायर की तो रेगुलेशन का राइट तो सिर्फ सेंटर के पास है, स्टेट लिस्ट में तो कोई एग्जिस्ट नहीं करता. सो व्हाट डिड द स्टेट से? स्टेट सेड कि भाई ये जो एम्पलीफायर के लिए हमने लॉ बनाया है, वी आर नॉट worried about, that whether it is a form of communication or not. What we are trying to regulate is health. कि ये जो noise pollution है उसको हम control कर रहे हैं. That is the motive or that is the true nature or character of the law. तो यहाँ पे true nature or character of the law क्या था? Health. That we are worried about the health. And state government ने बोला that health is a state subject. Health is not a central subject. Health is very much a state subject. तो इसीलिए हमारे पास right है and we can make the law. So Supreme Court agreed to it and they said that yes, now this is the true nature. What is the objective that you're trying to achieve by the act? The objective that you're trying to achieve by the act is something which is within the state list. If the objective that you're trying to achieve is within your list, then that is going to be considered as valid law. Right? So here court said कि ये invalid नहीं है. On the face of it, it might look कि आप center के law को encroach कर रहे हो, but in effect, the main purpose, the pith and substance, the true nature and character of the law is such that you are not going against it, right? So this is your doctrine of pith and substance. ठीक है? So far so good. I hope this is clear. This is again a very, very often tested area. अगर तुम लोग PYQs लगा रहे होगे, तुमने काफी बार इसके ऊपर based questions देखे होंगे. Right? So therefore, let's ensure that you guys are clear with this. So we move on. Once I know that there is clarity. अब जो अगला doctrine है ना, that's known as incidental and ancillary powers. Now this particular doctrine is supposed to be an addition. It's like an addition, or what you also refer to sometimes as it is like an extension of the doctrine of pith and substance. तो pith and substance में क्या था कि भाई 3 list में आपका again there is this overlapping which is happening. So the same is there in the doctrine of ancillary, incidental and ancillary powers. पर ये doctrine specifically क्या करता है? It says these powers which are given in the 3 lists. Now, the right of the government is not only to make laws regarding the specific subjects or topics which are given, but also on any supplementary or incidental subjects. Which means कि कई बार क्या होता है कि कोई specific law है, उस specific subject के ऊपर तो law बना ही सकते हो, but उसको achieve करने के लिए, in order to actually achieve the real goal, कि भैया इसका goal क्या था, इसके बारे में आप achieve कैसे करोगे. So that extra thing, something which is necessary, incidental and ancillary क्या होता है? Incidental होता है जो necessary होता है, which is like a by chance, it just happens. It is not कि आप intentionally you are trying to do add on to your power. आप जानबूझ के अपनी powers बढ़ा नहीं रहे हो, but that is something which happens naturally. It is something which is going to be a natural consequence if you want to exercise the power given in the state list. इसका एक बहुत अच्छा example है जब हम बात करते हैं state list कि this is also based on a case law. तो ये state list का एक subject था wagering and gambling के ऊपर, कि भाई state के पास पावर है ये वेजरिंग एंड गैम्बलिंग के ऊपर लॉज बनाने की. तो आपने आई थिंक यू मस्ट हैव सीन in some states gambling is permitted. It's not that I'm promoting gambling, but does anybody have any clue कि कौन से states में gambling या wagering is like हमने contracts में पढ़ा है. Wagering could be even your lottery tickets could be wagering. Lottery tickets are not valid in all states. Do you know in which states lottery is valid? कहाँ lottery valid है या any form of gambling is actually legally permitted? Any clue? It's not that I'm trying to make gamblers out of you. I'm not promoting that. अच्छा, ओए आनंद अभी आया भाई. Good evening, Anand. Okay, yes, Goa सबको पता है. Goa, yes, Goa is where gambling is permitted. But Goa में interesting fact है. Do you know in Goa you can gamble, but you can gamble only in the water. Okay, that's interesting. So in Goa, if you want to gamble, not that I'm promoting gambling, as I said already, the casinos are on the boats. Right, so they're all based on boats, and so if you really want to gamble, then you have to go to the boat, and you order a meal, and it's like a whole package, and then you can gamble, because you cannot gamble on ground. वही casino वाला अगर अपनी दुकान एक normal पंजिम में या कहीं भी गोवा में खोल लेता है, that is going to be illegal. Okay, so that's an interesting fact. Not very relevant, but it is interesting, right? Yeah, Nitya is saying let's go to Goa. Yeah, let's go after Clat. I think even I need a break after, like you guys of course need, but even I think I need a break. तो एक बार तुम लोग Clat दे दो. January is like the perfect weather also Goa जाने के लिए. Touch base with me, and we can maybe go. Nitya, basically idea is, why is it in water? I might not know the exact reason, but what I think could be the reason is in order to keep it curtailed. Otherwise gambling is something which could lead to a lot of other stuff, So you want to allow gambling, but you want to curtail it so that it can, if it's only in water, they would be in a better position to keep control over the same. So fair, that's what my interpretation is. So I wonder how true that is, but that's what I feel. Chalo, any which ways. So ye Goa, and somebody mentioned Kerala also. Sabne Goa hi Goa bola tha. Kerala mein bhi your lottery is allowed. So if you go to Kerala, you'll see a lot of shops selling lottery tickets. There's Sikkim maybe hai lottery allowed, things like that. Okay? So any which ways. So we come back to the example. So hum baat kar rahe the. Yes, Kushal, good. Kerala has lottery system which is state sponsored. Yes. So now we were talking about that state list ka subject hai ki bhai wagering and gambling se related law, wagering and gambling से related law state बना सकता है. दूसरा चीज है कि भाई wagering and gambling से related tax जो है वो भी impose कर सकता है state. So there are two entries. One is talking about gambling. State will make laws. Second is that tax can be imposed by the state government on this thing. Right. Now let's say the state government makes a law in saying that in order to impose tax impose karne ka law to bana diya, then they also make a law in which they are talking about search and seizure, that in order to ensure that people actually pay the tax. Let's say case happens that people stop paying the tax, logon ne tax nahi diya hai. So if you really want to implement the law, for that they have made a particular law regarding search and seizure. Now, search and seizure might not be included in tax imposition. It's not part of the state list. But in order to implement this tax law, is this something which they could make a law about? That you can search and you can seize the assets of a person who is not paying up tax? Do you think this should be allowed? Search and seizure? Would this be allowed? अच्छा भाई लॉटरी खत्म करो, कसिनो से बाहर आ जाओ एंड मुझे बताओ. अभी देखो, अभी तक तो कोई जवाब नहीं दे रहा था. The moment we started discussing Goa, everybody is in. So tell me now, will this be allowed or not allowed? Would the state be allowed to make a law regarding the search and seizure? Yes or no? Yes means they can make law. No means the law is going to be invalid. Yes, the answer is going to be a yes, right? Because end of the day, what are we seeing? That in order to collect tax, in order to have a proper implementation of collecting tax, the right to search and seizure will have to be there. Otherwise, why would people want to pay tax? People will start evading tax until unless uska implementation execution ka power aap state government ko doge. Till that time, it's not going to work. So therefore, if you look at this now, ab ye search and seizure ka power kahan se aaya? Ye search and seizure ka power aaya because it is something which is ancillary and incidental. Right? अब ये चीज जो है supplementary, incidental subject है. So therefore, this would also be included within the power of the state to do. That's what this doctrine basically talks about. इतना सारा ज्ञान दिया हुआ है मेरी स्लाइड के ऊपर भी, but basic idea यही रहता है कि ये करता है broaden. ये broad कर देता है, liberal interpretation देता है of the various lists which are given. So they're saying this particular doctrine is focusing on the fact that whatever are the subject matters which are given in the list, you have to give a very broad and liberal interpretation to them. Unka bahut restricted interpretation aap nahi kar sakte, because end of the day, what is the purpose that they're trying to achieve? That is the most important thing. In order to achieve that purpose, agar kuch additional cheez ko unko regulate karna pad raha hai, then that is going to be considered as lawful. Until unless kuch aap intentionally extract kar rahe ho to alag baat hai, but something which is naturally arising out of it, all that you can govern. Take. So that is going to be your doctrine of incidental and ancillary powers. Okay, let's move on. Next, jo hamara doctrine hai, that is the doctrine of repugnancy. Now, when you look at the doctrine of repugnancy, again, wohi topic hai. टॉपिक वही है हमारा. वी आर स्टिल ऑन द सेम फैक्ट ऑफ सेंटर एंड स्टेट. अब यहां बात कर रहा है कि भाई सेंटर एंड स्टेट का लॉ, अगर दोनों, देयर आर टू लॉज एंड देयर कॉन्ट्रडिक्शन टू ईच अदर. सो देयर इज अ लॉ व्हिच इज मेड बाय द सेंटर, and the same thing, there is another law which is made by the state, right? So there are two laws which are made by the center and the state, and they produce different results. So कौन सा वाला लॉ प्रिवेल करेगा? Inconsistency है, incompatibility है, then whose law will prevail? And this we are talking about when you are talking about the concurrent list, because otherwise state and center का तो specifically divided है कि भाई ये state का law है, ये center का law है. There is no overlapping or confusion there as such. But when you look at the concurrent list, it is always going to be both, either the state or the center can make laws. So both of them have the power. So what if both of them have made law on a particular subject, and then there is the question as to kiska law prevail karega? So general rule, I think everybody knows. Okay, Nitya is telling me center ka law prevail karega. Yes. So that's the general rule. Normally it is going to be the center, because हमने starting में क्या बोला था, हमारी country का कैसा bias है? Unitary. Right? तो सेंटर और यूनियन का लॉ हमेशा प्रिवेल करता है. दैट मीन्स इफ there is any repugnancy between the law, then it is normally the center will. But इसमें क्या है? There is certain exception. Now, what is the exception? The exception is that if the state has the state law जो बना है, जो कि repugnant है, it has been reserved for consideration by the president, and it has received his assent. मतलब आपने state का law बनाया है, and the state law has received presidential assent. Then in that case, even if the state law is going against the central law, the state law is going to prevail, right? तो मान लो कोई center का law था, but state ने अपना कोई separate law बनाया है after taking presidential assent. Then that law which is made by the state under presidential assent is going to prevail, and the state center law will not be applicable. So this is like an exception to the general rule. But इसी का दूसरा हो सकता है. Okay, Hasika, like for example, let's say there is a law regarding center. Okay, education could be a concurrent list subject, right? So education से related कोई law बनाया है that maybe for all graduations, let's say एक सेंटर ने लॉ बनाया कि आज से जो हमारी कंट्री में जितनी भी ग्रेजुएशन की डिग्री हैं वो मिलेंगी आपको 4 years में, right? So this is the law which is made by the center. ठीक. अब ये लॉ जो है, same, there is another state, let's say the state of Maharashtra, they have come up with their own law which says that graduation degrees are going to be for 3 years only. उनको लगता है कि ये 4 years 1 साल waste है, उससे अच्छा तो 1 साल कहीं नौकरी कर लेंगे, that's better. So whatever their logic might be, they are saying that graduation degrees are going to go for 3 years. Now here if you look at it, the law is on the same subject of graduation degrees. One is saying 4 years, the other one is saying 3 years. तो अगर हमारा normal scenario है, हम law of repugnancy use करेंगे, so obviously the state law is going to prevail, and ये जो central law will prevail, and जो state वाला law है वो declare हो जाएगा invalid. But what if the Maharashtra state had, before making this law, taken a special assent from the president for this particular law. उन्होंने ये law president को consideration के लिए दिया, and president ने बोला कि yes, you know, in Maharashtra there is a lot of opportunity and whatever, so they don't need to have a 4 years of graduation. For them 3 years of graduation भी चलेगा, right? So here in such a case, even though this is directly in conflict with the central law, the state law is going to prevail. तो यहाँ पे state law जो है prevail करेगा because of the fact कि यहाँ पे they have received the president's assent. तो अगर आपको president का assent मिल गया है, then the state law can prevail. But इसमें एक और exception है. एक और exception क्या है कि parliament still has the right to override such a law by making a subsequent law. That means कि मान लो पहले ये law था, उसके बाद जो हमारा सेंट्रल गवर्नमेंट है वो एक और लॉ लेके आते हैं, and now they are saying that very specifically that all the state laws governing duration of graduation will be declared void and only the central law will prevail, right? तो अब ये अगर बाद में होता है, मान लो this law was of 2010, जो सेंटर का पहला वाला लॉ था, फर्स्ट लॉ ऑफ द सेंटर, और ये जो स्टेट का लॉ था, ये हमारा सेकंड लॉ है, ये आया इन 2020, ठीक है? तो अभी 2020 में स्पेशल प्रेसिडेंट असेंट लेके आया, दैट इज व्हाई दिस वाज वैलिड. देन इन 2022 सेंट्रल गवर्नमेंट ये लॉ लेकर आ गए कि भाई अगर आप हम ग्रेजुएशन 4 years का होगा, and all the other state laws which have any other provision regarding graduation years, then that is going to be declared void. So अब क्या होगा, after this 2022 law, this state law in the year 2022 will lose its validity and will become invalid. फिर आ गया bias union की तरफ, ठीक है? So therefore, even though this exception is there, but this exception का भी एक bypass available है, ठीक? I hope this is clear now. So यहाँ पे it's a little tricky, but basically center, presidential assent, then even the state can prevail. But after that also, if the center wants to change it, the center has the power and they can declare it void or they can change, and center's law is going to prevail. ठीक? That is your doctrine of repugnancy. ये चीज हमेशा याद रखना, ये exceptional circumstances are the ones which generally create this confusion. ठीक है? तो ये वाली कॉन्सेप्ट को समझ के रखना है. बाकी तो रिपग्नेंसी नॉर्मली सबको पता है कि भाई सेंटर ही प्रिवेल करता है. But that's the little exception which has been created within the constitution itself. Like article 254 ही बात कर रहा है पूरा रिपग्नेंसी लॉ के बारे में, and 254(2) is the one itself which is creating the exception and the exception to the exception. Because literally that is what it is. There's an exception, then there's an exception to the exception itself. Okay? So that is your doctrine of repugnancy. I hope it's clear now. Hasika, can I see a thumbs up? Take. Chalo. Then we move on further. Okay. अगला हमारा जो डॉक्ट्रिन है, अगला जो हमारा डॉक्ट्रिन है अभी, दैट इज नोन एज द डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन. ठीक है? अब कलरेबल लेजिस्लेशन क्या बोलता है? कलरेबल लेजिस्लेशन बोलता है बेसिक आइडिया अगेन वही है कि भाई ट्रांसग्रेशन हो रहा है, यू आर मेकिंग लॉज ओवर विच यू डू नॉट हैव द पावर ऑफ मेकिंग, राइट? आप ऐसी चीज पे लॉ बना रहे हैं जिसके पास आपके पास पावर नहीं है. सो बेसिक आइडिया सेम, ट्रांसग्रेशन ऑफ इट्स पावर. नाउ what is the logic behind this particular doctrine is that say what cannot be done directly cannot also be done indirectly, right? So there is this Latin maxim also which is involved here, which is known as quanda aliquid prohibitor ex directo prohibitor et per obliquum. Abhi maine kuch bola hai, I wonder if that the pronunciation is correct or not. But basically this is the legal maxim behind this concept, right? So what does it say? What cannot be done directly cannot also be done indirectly. So if you are not allowed to make a law on a particular subject as per the list which you belong, whether it is state, center, either of the two. You cannot even make a law indirectly. तो आप जो directly नहीं कर सकते वो indirectly भी नहीं कर सकते. That's the general idea. Again, legislature power को divide करने वाला concept वही है. अब यहाँ पे एग्जाम्पल कैसे आते हैं इसके, जैसे कि लेट्स से फॉर एग्जाम्पल देयर इज दिस स्टेट सब्जेक्ट जहां पे बोला है कि भाई एग्रीकल्चरल इनकम जो है उसको टैक्स करने का राइट सिर्फ स्टेट गवर्नमेंट का है, राइट. सो एग्रीकल्चरल इनकम कैन ओनली बी टैक्स्ड बाय द स्टेट गवर्नमेंट. But what happens? The central government, under its power to impose tax, central government के पास generally power है for imposing tax. तो central government क्या करती है? Under this general power of imposing tax, it starts taxing agricultural income also. तो agricultural income जो कि normally subject था state का, आपने उसको include कर दिया on your general power of taxation. So it might be, on the face of it, it doesn't look as though it's incorrect. But is this something which should be allowed? Would it be considered to be valid? No, obviously not. It cannot be considered as valid, right? Because here what you are doing, like it says, the last sentence says, what is wrong is always wrong. And you cannot make it right by changing its mere color, language, or form. So here you do not have the right to tax. The right is with the state. The center cannot do it. If the center is doing it, it is doing something indirectly or it cannot do directly, right? So yes, Hasika, this would also result in double tax. बेचारे वो एग्रीकल्चरलिस्ट जो है उनके वैसे ही पैसे नहीं होते, तो मैं सेंटर भी टैक्स ले रहा है, उसके बाद स्टेट भी टैक्स ले रहा है. So obviously there's double taxation also, but this also comes under within the concept of colorable legislation, right? Something which is a subject matter of one a particular list, center का है या state का है, the other one cannot make any law, चाहे डायरेक्टली भी नहीं बना सकते और इनडायरेक्टली भी नहीं बना सकते, राइट. सो दैट इज द डॉक्ट्रिन ऑफ कलरेबल लेजिस्लेशन. जैसे इसमें एक इंटरेस्टिंग कॉन्सेप्ट, एक और एग्जांपल होता है वो एयरपोर्ट वाला, जिसमें बोलते हैं दैट द कंस्ट्रक्शन ऑफ एयरपोर्ट्स लेट्स से इज अ यूनियन सब्जेक्ट, राइट. तो यूनियन लिस्ट का सब्जेक्ट है कंस्ट्रक्शन ऑफ एयरपोर्ट्स, एंड जो हमारा स्टेट है वो क्या लॉ बनाता है, उसका सब्जेक्ट होता है एक्विजिशन ऑफ लैंड, right? So there is an acquisition of land which is a state subject. अब state ने क्या बनाया law that they are going to acquire land for building an airport. So here what are they trying to do? Would this law which is dealing with acquisition of land for building airport, would this law be valid or invalid? Would this law be valid or invalid? That you make a law for acquisition of land for building airport. ये valid होगा या invalid होगा? Quick, tell me. Valid, invalid, quick, जल्दी बताओ. एक रिप्लाई आया है मुझे हसिका का, बाकी valid law होगा या invalid होगा? Okay, I'll repeat the question. The union list has the subject of airports. Okay, construction, maintenance of airports is with the union, and the state list has the subject entry of acquisition of land. Now the state is making a law in which they're saying we are acquiring land for the purpose of building an airport. So in effect, what is the state trying to do? State cannot make an airport, but by saying that we are buying land for building an airport, you are trying to construct an airport indirectly, right? So what you cannot do directly, you are doing it by merely changing color, form, language, right? You are disguising it, and जो आपके ulterior motive है कि भाई हमें airport बनाना है खुद, that is coming into the forefront, right? So what you cannot do directly, you cannot do indirectly as well. That's what your concept of colorable legislation is about. Take care. I hope this is clear. So we move on from here to the next doctrine. Now, Next is your doctrine of waiver. अब waiver काफी simple है. Waiver normally क्या होता है कि if I have a right, you know, if it's my normal right, I have the right of waiving my right. कि कोई भी मेरे पास right है, मान लो मेरे को I have the, like if I'm traveling in a bus, if I'm traveling in a bus or a metro, किसी भी अगर मैं local transport में travel कर रही हूँ, so there is this always these seats reserved for women, है ना? So normally let's say there is the fellow who's sitting on that seat and he gets up looking at me कि हाँ मैडम आप बैठ जाओ, seat reserved for women है. But I feel कि नहीं, I am fresh, I don't need to sit. So can I waive off my right कि ठीक है, I don't want to sit, you sit. Can I do that? Can I let him continue to sit, or would I be bound to sit? Would I be bound to sit, or can I waive it off कि नहीं ठीक है यार तुम बैठे रहो? That is what waiver is about. Can you waive your rights away? Can you waive your legal rights away? And the answer in general would be yes. I'm like, of course, I can. Like if I don't want to sit and that poor fellow is sitting, I can see how tired he is, and I let him sit, I have the right to waive my rights. So अगर आपकी private individual right है, उसको तो आप waive कर सकते हो. Right? So normally, let's say there is a contract. Under a contract, I'm supposed to get 10,000 rupees from you. बट अब मुझे दिख रहा है कि तुम्हारा धंधा बहुत मंदा चल रहा है, तो मैं बोल दूं कि यार छोड़ो यार, तुम्हें 10,000 मुझे देने हैं, मेरे पास बहुत पैसे हैं, डोंट गिव मी द 10,000 rupees. So what am I doing? I'm waiving my contractual right. So under the contract I had this right, पर मैंने अपने contractual right को waive off कर दिया. This is my private right which I am waiving off. Right? तो जब ये private right की बात होती है, उसको तो आप waive off कर सकते हो. But when it comes down to fundamental rights, constitutional law के context में जब fundamental rights की बात आती है, उनको आप waive नहीं कर सकते. You cannot waive off your fundamental rights. The rights which are given under Part 3 of the Constitution, there have been a lot of case laws which says that you cannot waive off your fundamental rights because they are not just for the benefit of the individual, but they're a matter of public policy. ठीक है, तो आप अपने फंडामेंटल राइट को वेव ऑफ नहीं कर सकते. इसमें काफी कंट्रोवर्सी इसकी अराउंड द कॉन्टेक्स्ट ऑफ वेवर इज योर राइट टू लिव, वेदर इट इंक्लूड्स योर राइट टू डाई, कि भाई जो डेथ कॉज करने वाला या यू डू नॉट वांट टू लिव, योर राइट टू डाई होता है. कैन यू वेव ऑफ योर राइट टू लाइफ सेइंग दैट आई वांट टू डाई? Can you waive off your right to life? Because that is what right to die is. Right to die is that I don't want to live anymore, so I'm waiving off. Article 21 मुझे देता है right to life and personal liberty. भाई मुझे right to life नहीं चाहिए, तो that is why I am dying. Obviously. Why? Because suicide करना तो crime है. You try to commit suicide and you don't end up dying. You're supposed to be ending up in jail. Though there are changes in the law which have happened, but still the basic idea is that committing suicide is also an offense, which means you do not have the right to waive off your fundamental right to live. So that is why when you talk of euthanasia and all, when you're saying that I'm completely ill, I am like on my deathbed, what is the point of living like this? Give me something so that I die, I peacefully move on. But you do not have the right to do that. ये वाला right आपके पास exist करता ही नहीं है, because what in effect you're doing is you're waiving of your fundamental right. And by allowing it for one particular person, maybe you are, you are not really exploiting it, but there might be some other person who misuses it and exploits it. That is why it is not merely for the benefit of the individual, but it is a matter of public policy, because it affects many more people than just the individual concerned here. Like that is why fundamental rights cannot be waived. See, passive euthanasia is allowed, but passive euthanasia is when you're talking about basically removal of the support systems, right? So removal of the support systems, passive euthanasia is allowed, but not active euthanasia, right? So it's not really your because right to die, जब हम active euthanasia की बात करते हैं, वो होता है that I will do something which will in effect help me die. So that is something which is not allowed. Yes, the Aruna Shaba case in which passive euthanasia was allowed, basically removal of support systems. Take. So this is your doctrine of waiver. Okay. Next is your last, I think this is the last doctrine that we're going to do today. That is a doctrine of latches. Latches basically means delay, right? So normally doctrine of latches or doctrine of delay, relating to delay, is something which is applicable in all laws across. It's a principle, it's an equity-based principle. Ki somebody who is not coming to the court in time, who's not vigilant about his rights, then he does not really have any kind of right over them. So therefore, when you are looking at the concept of doctrine of latches, it says that those who slumber, people who sleep over their rights, they do not have any right to claim those rights anymore. Okay. So here, now normally, generally जब हम बात करते हैं doctrine of latches, तो legal system में तो applicable होता ही है. Which is that law which generally helps you in putting this doctrine of latches, implement this doctrine of latches? Can you tell me the act which is responsible or through which we implement doctrine of latches in India? Quickly बताओ, कौन सा है ऐसा हमारा लॉ जो कि हमें डॉक्ट्रिन ऑफ लैचेस को इम्प्लीमेंट करने में हेल्प करता है? सॉरी, which is the law which helps in implementation of doctrine of latches? Quick. लास्ट है ये स्लाइड, बस खत्म हो गया, 8 बज गए. Implementation, that अगर डिले कर दोगे तो फिर जस्टिस नहीं मिलेगा. Now we've done this a lot of times, when we were doing procedural law, even when we're doing contracts, we've done that. When I tell you the answer, you'll be like, oh, I knew this. Remember Limitation Act? Remember Limitation Act? Limitation Act क्या करता है? टाइम पीरियड प्रोवाइड करता है कि भाई अगर इतने टाइम के अंदर तुमने केस फाइल नहीं करा, then you lose the right to file the case. That's what your Limitation Act does, right? Oh, see? Yeah, I'm getting all those reactions now in the chat box की, of course, I knew this. है ना? तो I knew this नहीं करना है, अपने दिमाग की खिड़कियां इसलिए हमेशा खुली रखनी है. That's why I'm saying कि कॉन्ट्रैक्ट में भी करा है, प्रोसीजरल लॉ में भी करा है, हमने बहुत बार ये कॉन्सेप्ट करा है कि भाई लिमिटेशन एक्ट जो है लिमिट करती है योर राइट, योर टाइम पीरियड विद इन विच यू कैन फाइल अ केस. दैट्स एग्जैक्टली व्हाट डॉक्ट्रिन ऑफ लैचेस इज अबाउट, दैट विद इन a reasonable time you will file the case, otherwise not, right? So of latches jo hai, that is something which is applied, that now of course it includes knowledge of claim, unreasonable delay, neglect. अब ये सब अगर करोगे तो फिर अलाउड नहीं होगा आपका केस, राइट? सो विद इन रीजनेबल टाइम यू हैव टू फाइल द केस. नाउ वेदर doctrine of latches applies to fundamental rights or not is the basic question here, right? So when you look at the concept of fundamental rights, here usually they say doctrine of latches does not apply until and unless it is completely unreasonable. Only then आपका आर्टिकल 32 के अंडर जो फंडामेंटल राइट वायलेशन का केस फाइल करते हो, that is going to be denied, right? Usually doctrine of latches, they say, does not apply because it is not, because again, it is something which is of importance to the public at large. It is not just with the individual, it's not just the individual's right which is getting affected. तभी वो उसको हम बोलते हैं doctrine of latches इतना apply नहीं करता है. But of course, it has to be reasonable. अगर unreasonable delay है, कोई आपके पास reason ही नहीं है delay का, as to why you are filing the case so late, then your writ could be denied. Otherwise, reasonable delay can be considered, right? So therefore, fundamental rights may be, earlier there was an opinion that doctrine of latches does not apply. You can file a case whenever you want to, but no. Here also, Supreme Court is now of the view that no, doctrine of latches is going to apply even if it is a case of fundamental right violation, if the delay is unreasonable. ठीक है, तो doctrine of latches के साथ हमेशा दिमाग में अब I think I'm hopefully you guys will remember that we are talking about limitation. ठीक? Chalo. So this is where we are coming to an end of today's session. I hope this was helpful for you guys. So those of you who have been with me throughout the session, this one and earlier one, we have now covered most of the important doctrines under constitutional law. Okay, so next session that we have is going to be on something new, and let's see what that is. And those of you who are visiting us, who are coming across this video for the first time, coming across this channel for the first time, then please feel free to come visit us, look up our YouTube channel, and you'll come across very many interesting things which will help you in your CLAT preparation, right? Thank you so much, and take care, everybody. Okay. Chalo. Bye-bye. Thank you so much. Bye-bye. Have a great evening ahead.